So go ahead.
Yes, great. Thank you, Katrina, and thank you so much for organizing this, and thanks to everyone for being here. I'm Wendy Murphy. I am an activist, attorney, academic. I'm not even sure that's a real title, but that's a collection of the things that I do. I have been a women's rights attorney for over 37 years. I teach at New England Law Boston. I've been there for 22 years. I teach a seminar on violence against women and law reform. I am also an impact litigator, which means I file cases in state and federal courts around the country, usually to try and reform and change the law on behalf of women's constitutional rights and women's civil rights, including things like Title IX. I've been a litigator and an academic, so I've also published numerous scholarly articles on topics ranging from, rape and the Equal Rights Amendment. I have a piece coming out this month on the history of the Equal Rights Amendment in a peer-reviewed law review journal. It'll be out later this month on the history of women's struggle for equality and the Equal Rights Amendment. So that, by way of background, I will just launch into specifically the history of women's struggle. I'll do a really quick version of it. It's more complicated than I think I'm going to sound, than it's going to sound tonight. But I want to make sure we cover lots of bases. So there'll be time for follow-up questions if I go too quickly over something. And I also have a TED Talk, if you're interested in a TED Talk about the history of women's struggle for equality that's fairly new. If you're interested, just Google Wendy Murphy TED Talk. I only have one. So the struggle for women's equality, most people know, dates back to the beginning of our country in terms of struggle for equality in America. But the worst thing that happened that really cemented women's second-class legal status in America was in 1868 when the 14th Amendment was adopted. I know that sounds funny because we revere the 14th Amendment, but it had a language in there that at first glance looks terrific, looks super democratic, and egalitarian. And that language states that all persons shall have equal protection of the laws. Now, you would think that would be good for women because women are certainly persons if you just read the language. But in fact, the Supreme Court of the United States repeatedly refused to recognize women as persons under the law at all, under the 14th Amendment. In fact, women didn't become persons under the Equal Protection Clause until 1971, which most people are shocked to learn and had no idea was the case. Before 1868, women were essentially what we were in England, what our colonizer before our country began. We were the property of men. And to some extent, even after 1868, we remained the property of men because we didn't become persons under the law. Women were angry about that because the 14th Amendment also protected voting rights only for white men. So it did two really bad things to women: equal protection rights for persons, but women weren't persons, and voting rights for white men. The 15th Amendment came along a couple years later and protected voting rights for Black men, but women of all types got nothing out of either the 14th or 15th Amendments, which is why we immediately started fighting for the right to vote and equality. Those were the two things we started fighting for because those were the two things we didn't get in the 14th and 15th Amendments. Most of you know when we first filed a suffrage amendment in the late 1800s, which would give women the right to vote. It took a long time to get it. It took, I forget if the number is 47 or 48 years. It took decades. We didn't actually adopt the 19th Amendment until 1920. It took a long time. And as soon as we were done with winning the right to vote, we immediately turned our attention to the fight for equality. So we win the right to vote in 1920. 3 years later, we filed for the first time with Congress the Equal Rights Amendment. 1923, that amendment stated that men and women shall have equal rights. Now, that is not what the Equal Rights Amendment says today, because that language changed in the 1940s. Mind you, I'm not sure it should have changed. I think it should have said men and women shall have equal rights, because it was only women who didn't get equal rights in 1868. Nevertheless, In 1943, the Equal Rights Amendment was changed to state what it says today, which is equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Changed the word woman to sex, which is fine, and I'll get to that. It was filed in 1923, changed in 1943, but a whole lot of nothing happened between 1943 and the civil rights movement of the 1960s because neither political party supported women's equality. Women struggled to get either party to do anything with the ERA between the 1940s, when the language was changed, and the early 1960s, when the civil rights movement really started in earnest. And women benefited tremendously from that. Of course, we shouldn't even call it a women's movement, because if you think about it as a civil rights movement and a women's rights movement, it sounds like those are different things. They're not. Nevertheless, what women were fighting for during the civil rights movement was equality. We wanted the ERA. And because the leadership at that time was headed by Alice Paul and the National Woman's Party, which was fiercely nonpartisan, because it knew that neither party supported women's equality, it was going full steam ahead and making great progress. And because of Alice Paul and the National Women's Party, we got the ERA passed by Congress finally in 1972. Now, some of you may have been around back then. I was, and women were celebrating. But we weren't done yet, because under Article 5 of the Constitution, an amendment does not become law just because it passes Congress. It then has to be ratified by 3/4 of the states, or 38 states. So it literally went from Congress to the states in 1972 and was moving like wildfire through the states. We quickly got to almost 35 states within a year or two, and then things stopped. Now, why does this matter? Because the support for the ERA faded pretty quickly after it passed Congress. And there are lots of reasons why that happened, but the short answer is both parties actually did not want the ERA to be ratified. Now, how do we know that? Because when the ERA passed Congress in 1972, it was burdened by a 7-year deadline, a 7-year ratification deadline. Prior to 1971, the ERA had no deadline. It was submitted to Congress in 1923 and in 1943 without a deadline. That was important because it took us decades to get the vote. We were not likely to get equality fast either, but it happened. Both parties supported adding a deadline at the last minute, and as soon as that deadline was tacked onto the ERA, it went lickety-split through Congress because both parties knew it would die before the deadline expired, and they were right. In fact, Alice Paul, the head of the National Women's Party, was seen crying in Washington, D.C. the day everyone else was celebrating, and they thought it was tears of joy. It wasn't. She was sobbing because she knew the deadline meant the ERA would never be ratified in time, and she was right. When the deadline came close to expiring, it was extended for almost 3 more years, and then that deadline expired in 1982. In 1982, we had made it to only 35 states, so everybody thought we should give up. It was over. We lost. We have to start over. Then something interesting happened 10 years later. In 1992, the 27th Amendment was ratified, and women were furious because that amendment had been given 203 years to ratify. It had been passed by Congress in 1789. It got 203 years to ratify, and women cried foul. How can you give something as important as equality 10 years to ratify, and you give the timing of congressional pay raises 203 years? I don't think so. Women decided right then and there we were going to go get those other 3 states. We were not going to start over. We would get 3 more states to ratify and then fight in the courts if necessary to argue about why the deadline on the ERA is unconstitutional. It cannot stand. You cannot have such a frivolous constitution that lets some amendments take 2 centuries to ratify and others get only a handful of years. This was our plan back then in 1982. Then in 1992, Then in 2012, things got even better. Why did they get better? Because the United States archivist, whose job it is to put new amendments in the Constitution after they're ratified by the requisite number of states, the United States archivist issued a public letter saying, if women get 3 more states to ratify, I will put the Equal Rights Amendment in the Constitution, even though the deadline expired. This is what he put in writing, that the deadline was irrelevant to him because his job is to publish the ERA in the Constitution the minute the last state ratifies. In fact, there's a federal statute right on point. 1 U.S. Code, Section 106B states, the United States archivist shall forthwith publish new amendments in the Constitution forthwith when the last necessary state ratifies, when the last of 3/4 of the states ratifies. He put that in writing. So women started investing huge amounts of resources and time into getting 3 more states to ratify, and led by Equal Means Equal. You're going to hear from their director, Kamala Lopez, in a few minutes. Equal Means Equal headed up a lot of the activism to get Nevada to ratify in 2017, then Illinois in 2018, and last but not least, Virginia ratified in 2020. Being the litigator and anticipating that we were going to have to go to court once we got to 38 states, because none of us thought that everybody would just roll over and let us win the ERA. We knew this was going to be a court battle. So I was already planning the legal action we would need to take. I just didn't know who I was going to sue or what I was going to need to file. And it became clear pretty quickly that when Virginia finally became the last state to ratify in January of 2020, I filed a lawsuit in federal court in Massachusetts against the federal government because the archivist reneged on his promise. He told us he would put it in the Constitution, and then he backed down. And he backed down because then President Trump's Department of Justice issued an opinion letter saying the ERA shouldn't be put into the Constitution because the deadline expired. I sued the national government. I sued the archivist, saying that he had no discretion not to put the ERA in the Constitution. Another lawsuit was filed after mine. I filed on behalf of women as a class of people. Another lawsuit was filed in DC federal court after mine was filed on behalf of the last 3 states to ratify. That was a states' rights lawsuit. Both of our cases were dismissed on procedural grounds, which was unfortunate. But here's the most important thing I want to share with you. When I filed my lawsuit, when the both lawsuits were filed, the Trump administration was in office. He blocked the ERA with that letter from the Department of Justice. His Department of Justice also fought against both lawsuits and argued that the ERA was not valid. Women very much then eagerly voted for Joe Biden and Kamala Harris in 2020. In the 2020 presidential election, both of them said they supported the ERA. So women voted very aggressively for Joe Biden and Kamala Harris. And as soon as Joe Biden got into office, we waited for 2 things. 1, unblock the ERA, rescind that letter from the Department of Justice, preventing publication of the ERA, and stop fighting against our lawsuits. And guess what happened? Joe Biden kept fighting against me in my lawsuit, argued against me in the First Circuit when I appealed, and adamantly opposed women's equality in his briefs and in oral arguments. And he made exactly the same arguments in his briefs that the Trump Department of Justice had made against me in their briefs before Biden took over. They did exactly the same. DC case argued against the ERA, and to this day, President Biden is blocking the ERA, not only because he hasn't rescinded the Trump administration's block on the ERA, he added his own. So where are we today? We now have this unfortunate moment in time where we have watched both parties very aggressively oppose women's equality in this country without justification, without any legitimate argument beyond technical legal things about deadlines. It's not, equality is more important than the damn deadline. And let me be clear, many constitutional scholars agree with us that the deadline is not valid. We didn't just make up the argument. Many scholars agree with us. So the question is now, how can any woman in this country vote for either of the major parties' candidates, knowing that neither of them support our right to basic legal equality under the United States Constitution?